Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists and uncertified podcast co-hosts. We try to bring our audience of trial and appellate attorneys some news and insights they can use in their practice. If you find this podcast helpful, please recommend it to a colleague. If not, there's always opposing counsel.
And a quick thank you to our sponsor, CaseText. CaseText is a legal research tool that harnesses AI at a lightning-fast interface to help lawyers find case authority fast. I've been a CaseText subscriber since 2019, and I highly endorse their service. Listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
All right, Jeff, it's time for a cases and tidbits episode. We do so many episodes with guests with interesting perspectives, but all the time there are new cases coming down the pike. We like to cover those that have talk about interesting procedural quirks that trial attorneys and appellate attorneys need to know about, need a bookmark for their file. Okay, so the first up, I want to talk about Bader versus Johnson and Johnson. This is one of those mesothelioma cases. This involves an issue of dealing with expert witnesses, expert opinions. Everyone knows about the Sargon opinion now, that you can exclude expert opinions if they're speculative, citing the Supreme Court Sargon opinion. But that's not the only the only objection to be thinking about when you have opinions who have out there theories. So if you're preparing for an expert witness at trial, you'll want to know about Sargon, as we talked about. Sanchez, you can't use case-specific hearsay through an expert. And so these are kind of the go-to objections, but don't forget about the 1976 opinion in Kelly. So here's what happened in this Bader versus Johnson and Johnson case. It was a talcum powder manufacturer where the defendants, they raised Sargon to one of the plaintiff's expert witnesses. The plaintiff wound up recovering a $12 million verdict based in part on this expert's novel opinion that fibrous talc causes cancer. The defendants had argued that the broader consensus of experts did not agree with the plaintiff's expert. This was too novel a theory, was outside of the consensus of science. So the defendants objected on the basis of Sargon. Sargon Enterprises versus University of Southern California. That's the 2012 California Supreme Court opinion. But that was the wrong objection the Court of Appeal held. The court noted that Sargon does not speak to whether a theory has achieved a consensus in the field sufficient to render it generally accepted. So if the defendants had wanted to object that the expert's opinion was a novel theory and not generally accepted in the scientific community, their motion to exclude did not challenge his testimony based on Kelly and its progeny. So that was People versus Kelly. We'll put that case in the show notes. So the upshot is, if you got objections to an out there theory by an expert witness, don't stop at Sargon. Sargon's not a substitute for objections to novel and not generally accepted scientific theories. So make sure People versus Kelly is in your expert witness toolkit.
And don't forget about Sanchez.
And Sargon and Sanchez. That's right. You got to get them all in there. All right. Next case up, I wanted to talk about Kowal versus Superior Court. This deals with the question, I have this under the header, a timely motion for summary judgment is entitled to a timely hearing. That was the holding out of the 4th District Division 1 in Kowal versus Superior Court. So what happened here, this is a familiar story for all trial attorneys. You file your motion, you're ready to go, you want to get that heard, and the hearing date is set months and months in advance. In this case, it was a summary judgment motion. Those are always going to be set months and months in advance. The problem was, it was set months and months so far in advance or out there on the calendar, it was even behind the trial date. So that's a problem. No point in doing a summary judgment hearing if you can't get it heard before the trial. So the moving party filed an ex parte application to have the MSJ hearing advanced to before the trial date. And the trial court said, no, you waited too long. You had long enough to file your MSJ. I've got calendaring problems, so can't help you. The moving party took this up on a writ petition to the Court of Appeal, and the court granted a peremptory writ and said,
"What a gutsy writ, huh, Tim? Isn't that a gutsy move, filing a writ on this?"
It is, because you're probably going to lose, and then even if you win, as the petitioner did here, you've got to go back to a trial judge who's probably not that trial judge's favorite person anymore. But the Court of Appeal published its opinion granting the peremptory writ. The court held that the trial court's calendaring issues are not a basis on which the trial court can refuse to hear a timely filed summary judgment motion. The court published the decision, quote, to provide guidance on the deadline for filing a summary judgment motion that is served electronically. There was an interesting issue about it was served, almost exactly 107 days. So it's 75 days notice plus 30 days before the trial date. So that's 105 days, and it was served 107 days. It was served electronically. So you got it had to be served 2 court days ahead of that, and it was served right on the dot, not a day too soon.
So you entitled or summarized this case as a timely MSJ is entitled to a timely hearing. I would summarize it as a last-minute MSJ is a backdoor way to get a trial continued, because with this published decision, it seems like trial courts are going to opt to simply kick out a trial date.
Yeah, that's a very strategic way of looking at it, but yeah, that's true, and that was the alternative relief that the moving party sought here: either advance my hearing date on the MSJ or kick out the trial date, and that was exactly why the opposing party opposed it. Yeah. But there are other cases that this case reminded me of that local rules and local rules cannot override the Code of Civil Procedure and the rules of court concerning calendaring of motions. So there have been other cases where trial courts have decided, it would be to everyone's best interest if they met and conferred before they filed a motion for summary judgment. Can't do it. The Court of Appeal says, look, we sympathize, that makes sense to us, but that's a legislative determination. Which is interesting. I'm doing some research on this other presentation, Jeff, and California is of the minority of states in which the legislature decides court procedure. There are the majority of other state courts, and California follows the federal model in that regard, where Congress decides court procedure. But most other state courts, their internal rules are governed by the judiciary branch itself. That was interesting.
Yeah,
maybe we'll talk about that more in the future. All right, and the last case that I wanted to talk about before we get to your 3 zingers, Jeff, I filed this under the heading vexatious litigant determination is appealable, and we had covered a case a few months ago where the opposite was true. But here's what happened in the published opinion in Blizzard Energy versus Schaefer's. And I'd like to think that our listeners are probably not a lot of vexatious litigants, but I always find these issues interesting about how the court decides what is appealable and what's not. So what happened is that a frivolous cross complaint, the holding is that a frivolous cross complaint counts toward the 5 frivolous lawsuits that an impro litigant may file before being deemed a vexatious litigant. So the trial court had refused to declare Schaefer's a vexatious litigant because one of his lawsuits was a cross complaint, and the trial court thought, well, does a cross complaint count as a lawsuit? I don't think so. So no, it's not one of you haven't filed 5 frivolous lawsuits, so you're not a vexatious litigant. And Blizzard Energy challenged that, and the Court of Appeal agreed that a frivolous cross complaint counts as one of your 5. But how did Blizzard convince the court to grant review of that order? Because the court wound up parting ways with the first district opinion from earlier, or back in 2022, where the second district here held that an order declaring a person to be a vexatious litigant is the equivalent of an injunction. And remember, under Code of Civil Procedure 904.1, the appealability statute, orders granting or denying injunctions are appealable orders. So that was the angle that Blizzard Energy pursued here, that, well, a vexatious litigant determination is not among the appealable orders, but it's kind of like an injunction order where it's telling when you declare a litigant a vexatious litigant, you're saying you may not file any more lawsuits. That's like an injunction. And this here was an order denying an injunction. So it's appealable.
And yet, for purposes of deciding the appropriate standard of review, typically injunctions are reviewed with deference, either abuse of discretion or substantial evidence for factual findings. And here, the standard of review was de novo. They said it was legal questions. It's just odd. It seems like the court really wanted to review this order to construe it as an injunction for purposes of a appealability and jurisdiction, but not an injunction, or not the traditional standard of review for injunctions.
Yeah. In the case we had talked about last year, this same argument was raised and that was an order finding that the litigant was vexatious. And so the vexatious litigant appealed that and said, hey, I'm not vexatious. I want review of this order. And it's like an injunction. So Court of Appeal, you should review my direct appeal as an order reviewing an injunction. And the court said, nah, it's not an injunction. It's not reviewable at all. So you're hosed. And if you remember, Jeff, I disagreed with that ruling last time around. I thought that it should have been reviewable as an injunction. At least the appellant had cited, a precedential authority or a published authority on that point that held that a vexatious litigant determination is like an injunction for purposes of appealability. But now looking at it again, I'm not so sure. Orders that restrict or require actions in the real world, injunctions, telling someone to unlock the doors to a business partner, or
Right.
Hand the passwords over, give access to the bank account, that sort of thing. Those are different from orders that restrict or require actions in court world. Orders requiring a corporation to pay dividends, that's an injunction, and so it's appealable. Orders requiring a corporation to produce documents in response to discovery, a discovery order, is that an injunction, Jeff? Not a chance, right?
Right.
Yeah, what else is the difference? The only difference I can detect is that one affects the party litigants' actions in the real world, and the other affects their actions in court world. And usually orders governing conduct in the court are not considered to be injunctions. And so I tend to think that maybe that first, the decision that we reviewed last year was correct, that vexatious litigant determinations, whatever else you may think about their reviewability, they're not injunctions.
Got it. Well, it's good to know your mind can be changed, and next you'll be deciding that SLAPP fee awards are not automatically, or are automatically stayed on a wall.
That's right. And by the way, that opinion that we covered was the Luckett decision, and that was on episode 42. We'll put links to those in the show notes.
All right. So now I've got 3 cases that caught my eye this week that I wanted to discuss really quick. And those 3 cases won't be any surprise to our audience. One is a SLAPP, one involves the First Amendment, and one involves Zoom proceedings for a trial. So let's start first with the SLAPP issue. A super interesting one called White v. Davis. Now, I am seeing in my practice an increased number of anti-SLAPP motions filed in response to restraining order proceedings. These are not civil lawsuits, but special proceedings like a civil harassment restraining order, domestic violence restraining order, elder abuse restraining order. And in these cases I've been involved in, the trial court's not careful. An anti-SLAPP motion can be used strategically by the respondent as a strategic motion against credible claims, or a SMAC. Consider that if the trial court hears the anti-SLAPP motion before the restraining order is heard, the loser of the SLAPP motion can immediately appeal and stay the restraining order proceedings from ever commencing. And that could defeat the purpose of these special proceedings to get an expedited restraining order without all the trappings and slowdown of a traditional lawsuit. So what do you do about these competing policy issues of wanting meritorious anti-SLAPP motions heard quickly, and you want meritorious restraining orders heard quickly? This was the issue in White v. Davis. This is a January 5th case, and the 4th District held that the trial court abused its discretion by not using its inherent case management tools to hear the anti-SLAPP motions concurrent with the restraining order, or granting the restraining order first, having it in place, and hearing the anti-SLAPP motions second. So if you are an attorney representing a party seeking a restraining order in one of these special types of proceedings, and the other side attempts to file a non-meritorious SLAPP motion, like a SMAC, to obtain a delay in the issuance of the injunction, just take a look at White. It's an interesting procedural case, and it pumps up the power of the trial court to manage its own docket.
Yeah, is the stay imposed by the anti-SLAPP motion that can be set aside in the discretion of the court?
So, it's interesting. The stay only really relates to discovery in terms of the filing of the motion. And then discovery remains stayed in terms of if there's a filing of an appeal. And the real question is, does the trial order have the power, does the trial court have the power to do anything once the anti-SLAPP motion's been heard and denied? I don't know if there's any cases on point there, but the solution really is to hear the anti-SLAPP motion concurrent with any restraining order. That's the elegant solution.
Yeah. So make sure you get the restraining order teed up and on the court's docket before the anti-SLAPP motion is heard.
Yeah, exactly.
Yeah,
exactly.
No, yeah, that is interesting, and I did see the White case come up on my feed as well. I thought that's a very interesting issue. I'm glad you brought that to our attention.
Thank you for letting me talk about a SLAPP case. You know how I love the SLAPP cases. All right, so next one I want to talk about is in your neighborhood, Lathis versus City of Huntington Beach from the Ninth Circuit from January 5th. And this concerns the removal of a volunteer on a city advisory board for political reasons. Now, I read the headline on this case. I immediately thought that can't be right, but eventually I came around and I think I agree with what the Ninth Circuit did here. So in this case, we're going to be talking about a city council member who's the appointer, and the volunteer who gets appointed to a city commission, an advisory body, that's the appointee. And here the volunteer appointee was photographed at a political rally standing next to someone from Antifa. And the appointer, the city council member, asked the appointee, the volunteer, to give a statement denouncing Antifa. And the appointee did so, but the statement was not strong enough or not to the liking of the appointer council member, and the council member dismissed the appointee from her position on the board. The appointee then filed a lawsuit arguing two things: that she was removed in retaliation for First Amendment protected activity, and also that somehow the First Amendment was violated through compelled speech when the city council members asked her to give a statement denouncing Antifa. So the appointee lost at the district level, and that result was affirmed in the Ninth Circuit. And it was interesting. The thing I found interesting about this is that your city and my city differs in terms of how they appoint people to advisory boards. In my city, like the Planning Commission and other advisory boards, the city council votes out large, or all 5 members of our city council vote, and that's how the people are appointed. But in your city, one council member appoints one member to advisory body, and that member is the face or spokesman or political voice of that city council member. It's
like an extension of that person. Yeah. So does that change the First Amendment analysis, do you think, if the appointee is appointed by the council at large?
Yeah, so let me quote the Ninth Circuit. We agree with the district court that the critical issue is whether Lathis was effectively a political extension of the council member, and concluding that under this particular statutory scheme, the appointee was effectively the city council member's, quote, public face. We affirm.
Interesting.
Yeah,
that came across. I wasn't planning to talk about that, but it came across my desk as well because it's out of my city. That's interesting. I was trying to imagine, this particular city council person is not my political persuasion. So I was trying to imagine, and I tended to agree with the outcome. I tend toward the more free speech absolutist, but I thought I followed the Ninth Circuit's rationale here, and it seemed right to me. I was trying to, and it's always important in these kind of things to imagine, imagine it on the other foot, and would I agree?
Yeah.
I don't know. So what do you think, Jeff? Do you agree with this outcome?
I think your city needs to change its policies for appointing people. That's the first thing. But yeah, I tend to agree with the Ninth Circuit in this circumstance for this particular way of choosing people to serve on committees. It's more of a political extension, and that is the deciding factor. But in my city, if someone is put on a planning commission, let's say by a vote out of 3 out of 5 council members, that person should not be able to be removed based on First Amendment activity. It's just, that's my view. So go ahead and go ahead and start reforming your city charter. Okay.
Well, and just a commentary on that. Again, I haven't looked into this, so this is just based on recollection. But it was only a year ago, a year or so ago, that we had one of the appointees to a board. It's a fairly innocuous board. It's the Huntington Beach 4th of July Planning Commission. I should be careful here, and I'll at least give a disclaimer. My wife is the chair of the 4th of July Planning Commission, but one of the other members of that commission was removed a year ago for maybe for comments made on social media, and I thought, well, that's interesting. Now, considering this case, if that person is an extension of the city council person, city council person can't be removed. So can that council member's appointees be removed by just by a majority vote of the board?
Yeah, interesting. And by the way, your city charter or the statutory scheme says people could be removed from a commission with or without cause. I think that was another important fact for the Ninth Circuit.
Yeah, and of course, if the bylaws or the charter allow for or ordinances allow for procedures for removal, then I assume those were followed.
Yeah. All right. Let me talk about the last case as we wrap up here. The third case I want to talk about is U.S. versus Knight. It's a Ninth Circuit decision. And this case caught my eye because it involves Zoom proceedings during COVID, but also I'm always interested in the distinction between, in the federal world, structural error, where an error results in automatic reversal, or non-structural error, where you have to show prejudice, similar to state court decisions. And so this was a criminal case where one juror watched the first 2 days of a criminal trial on Zoom, was not present in the courtroom. And the criminal defendant stipulated at trial to the remote proceedings. And the defendant was convicted and appealed. And the Ninth Circuit sidestepped the question of whether it was appropriate or not to have a remote proceeding, because the defendant stipulated it's okay for this juror to be on Zoom. So the question in the case was, assuming it was error to allow a juror to participate remotely, is that error structural or not? And the Ninth Circuit looked at it and said, I thought in kind of a thinned down, weak analysis, the Ninth Circuit said, this is not the kind of error that results in, commonly results in prejudice. And so they decided that in the absence of a specific showing of prejudice, this is the kind of error that is waivable. So when a criminal defendant waives the right to have all the jurors present in the courtroom for proceedings, they can't then in an appeal argue it was such an important constitutional right, they didn't have the ability to waive it.
Yeah, remind me, Jeff. I remember skimming this very quickly, and I recall that the court had listed some other types of structural issues that were not waivable. Do you recall examples of the kinds that are not waivable?
Exactly. The right to an attorney, I think, was one of them. I think the right to confront witnesses was another. I mean, they're the big ones that we learned about in law school.
Yeah. So this was not a waivable one. I don't know what the standard is for deciding what is a waivable, a structural issue and what's not.
Yeah, I think this one was based on the record before it. There wasn't a whole lot of evidence that how this juror's experience in jury proceedings was different than the in-person jurors. And on that basis, the court didn't have a lot of ammunition to work with in terms of concluding that this is the kind of error that should be structural.
Yeah, although if it is structural, those are that's a determination that it defies review for harmlessness, and so it's basically just up to the judge's imagination. Is this the sort of thing? If a jury had been excused for the entire trial, not excused, but allowed to observe the trial remotely for the entirety of the trial, rather than, I think it was just 2 days here.
Yeah.
Would that be a structural, or what if the entire jury was permitted to observe remotely rather than in person? That seems like it would be structural.
Yeah, I think the fact that the defendant stipulated here and the fact that it was only 2 days, not the entire trial, means maybe this won't be the final word on the subject of whether these are structural or not, but the record here wasn't sufficient for the Ninth Circuit to make any new rules on this.
Yeah, not the best case to launch off a new finding of a structural error. Okay, no, yeah, great. Those are three great cases, Jeff. Now, do we have a couple of tidbits you want to share with the audience?
I have one. I was actually interviewed earlier this week. It involves about this case back east. There's a big law firm, the Proskauer law firm. Imagine, Tim, you used to be a computer guy in a prior life.
Yeah.
Imagine you're the head of IT at a big law firm, and the COO, number 2 guy at the law firm, comes to you and says, "Hey, I've got this thumb drive. I want to put stuff on this thumb drive. IT guy, would you please disable the security parameters that usually prevent removable storage devices from being used in this way?" And the IT guy says, "Why?" And this law firm officer, the number 2 man, says, "An outside vendor needs it." So the IT does it. The IT guy does it, removes the security. The COO of the law firm downloads all of the firm's data regarding partner compensation, practice groups, and productivity of clients and practice areas. Not client data, but productivity of the firm. And turns out this COO then decided to delete 1,000 emails involving him in violation of a litigation hold that had been placed on the computer, and gave notice that he was quitting. And he fired off an email to somebody saying, "Boy, my employer is not going to be happy when they learn who I'm going to work for." So under those facts, the law firm back east filed a lawsuit, got a restraining order, temporary restraining order, preventing him from using that thumb drive or sharing these files, in order to show cause, explain himself to the court as to what he did and why he did it. And I think today or yesterday, he filed his response saying, "Oh, I was getting ready to go on vacation, and everybody likes to work on vacation, so I downloaded those files so I could work over my vacation." I don't think the judge has ruled yet on the preliminary injunction. It's just ruled on the restraining order, but that's where it is. And I bring this case up because it's an interesting security issue for big firms and little firms in terms of how they secure their data, and how it's usually good to have a check so that not just one person can access key sensitive data like that.
Yeah, no kidding. That's a scary story. The COO said that I was just taking the thumb drive to work remotely, but did he explain also why he simultaneously deleted thousands of those emails? Oh, when you go on vacation, you always, delete 1,000 emails before you go.
When there's a litigation hold because of pending litigation about those emails. Yeah, I don't know that he's explained that one.
Yeah, no, that is a good cautionary tale for having good internal procedures. And yeah, like you said, having like a 2-step check, advising your IT people, don't just take it on the authority of one person to override important security parameters. Yeah, that's the only tidbit I had this week. Do you have anything? No, I think we can wrap it up for this week. So let's thank our sponsor once again, Casetext, for sponsoring the podcast. Each week when we include links to all the great cases we talk about, we use Casetext for our case database. And listeners of the podcast can find a 25% discount available to them if they sign up to Casetext at casetext.com/CALP. That's casetext.com/CALP. And if you have suggestions for future episodes or an explanation of why someone would delete 1,000 emails, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for appeal when preparing for trial. All right, see you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.